Donald Trump now facing a formal legal demand to go under oath in this big investigation that New York Attorney General Letitia James has been leading. She is subpoenaing him to testify. The goal there to get him to sit down for a deposition on January 7th and answer for allegations of corruption and lying to authorities about his business, as well as the view that fraud permeated his company, which he denies. This is a civil probe. James has said state laws apply to Donald Trump like anyone else.
President Trump cannot avoid justice in the great state of New York. My investigation is civil in nature. However, in the event that we uncover any conduct or activities which would suggest criminal activities, then that would change, obviously, our investigation.
Attorney General James has been probing some Republicans like Trump and some Democrats like former Governor Cuomo. She was actually beginning a run for governor, which would be the job that he did vacate, but today announced she's dropping out of that race. That is sort of New York campaign news. In this case, Trump denies any wrongdoing and has yet to signal how he would face these new calls to testify, although we have a track record of delay and dodging with these kind of situations. That's not all. Trump also hit with more bad news. New York's not the only place where there is this push for accountability. Late today, a top federal appeals court dealt Trump another loss in his attempts to hide evidence from January 6th. And that leaves him with one more legal Hail Mary, which is his right, and that would be to make moves in court to get the Supreme Court to try to bail him out. I can't tell you yet whether they'll do that. It is an option his lawyers say at this hour they are still considering. It's breaking news, so let's get right to it. We are joined by former SDNY chief David Kelly, also full disclosure, my former boss, and former RNC chair Michael Steele, who did support Joe Biden in the race. David, what does it mean when you look at these developments, one from the New York AG's office and the other about evidence?
Well, look, I think she's putting him in a really tough bit of a pickle, because from a legal perspective, the way to get out of the deposition is, say, to invoke your Fifth Amendment right against self-incrimination. From a public perception, from a political perception, and I'm sure Michael has a lot to say about this, whether or not he wants to come out and say that I'm going to incriminate myself if I testify truthfully. So it's an interesting dilemma for him. It's not a complicated legal issue by any stretch. I think it's more of a political issue for him than anything else.
And David, you have been in all kinds of cases on both sides. As mentioned, you ran the famed SDNY. You've also been in clashes with the government on behalf of clients. Scuffling over evidence is part of it. The news tonight, though, seems to be that the scuffling is not working for Trump, which is to say there's nothing wrong or prejudicial about lawyers and clients trying to say, well, you don't get this or that's out of scope. But I want to read from this new federal appeals court ruling, which says January 6 exposed the fragility of democratic institutions that some may have taken for granted. The president, the current President Biden, makes the judgment that access to these presidential communication records is necessary. Trump has given this court, quote, no legal reason to cast aside President Biden's assessment. David, what does that mean to you about the prospects of reversing that in the last shot, the Supreme Court?
No, look, this from any legal any lawyer looking at this case from the get-go, no one really expected that there's a legal basis to rule in Trump's favor here. It's pretty silly. And what this is really,
let me slow you down, because he's trying to invoke something that's the president's to invoke, and he's no longer the president, regardless of what QAnon or somebody else says?
Exactly. Among other things, yes. And this is really, this whole thing is Trump's typical MO of trying to put this into a four-corner press and slow it down and try to run out the clock. And obviously, the Court of Appeals today ruled that, well, that's not going to work here. Question is, how much more clock does he have to run by going to the Supreme Court? I don't think this is it wouldn't surprise me if the Supreme Court denied cert. It's not a really controversial legal issue, I don't think, although because it turns on the executive privilege, which is pretty high up there, obviously. The Supreme Court may take it, but I don't think they're going to let him run the clock too much longer.
And when you say not cert, you just mean the court might not even look at this as worth hearing, and they might just leave the loss in place for Trump.
Right. I meant certiorari, which means granting Supreme Court review.
Did you know that's what that meant, Michael? Just kidding.
Absolutely.
Michael, your name and judgment.
No one's ever accused me of throwing around too many legal terms.
Hey, you know, David knows a lot more, I could say this, than either of us about these intricacies, having run the entire Southern District of New York. But all jokes aside, Michael, your name and judgment was invoked by the counselor. So go ahead.
Yeah, no, I think counsel's put it out there exactly as it is, and this is what a pincer move looks like, to put it in political and military terms, if you will, between the state of New York and the Court of Appeals. You have this pressure now, this legal pressure at the state and federal level that have boxed Trump into a corner. But here's the question, does that pincer move latch on to something real and substantive that forces Donald Trump to not only appear, but then to either invoke the Fifth and go through the process? Or does it latch on to Jell-O? In which case it just slips through the legal process, is delayed. There are all these other hurdles that are put out in front of it. I don't think that is so much in this case, but that's something you also have to look at and be concerned about, and that's where the Supreme Court's going to come in. I think at the end of the day, counsel's right. The Supreme Court will likely deny cert, but at the same time, there is a chance, and Maya Wiley made this point on Nicole's show, that because the conservative wing of the court is so hell-bent around an augmented executive branch, that they could see this as an opportunity to tinker and to explore. But I think at the end of the day, the precedent and quite frankly, the politics would say, don't touch this. The last thing the Roberts Court wants, particularly after the abortion fiasco that they've now found themselves in, is to further politicize the court. They've opened that now. They've taken on these cases that have high political drama to them. And this is one piece they don't want to add to that, particularly for those three new appointees of Trump, who, could then be blamed as, sycophants just doing Trump's bidding. And that's not a stain that Roberts wants on his court.
What Michael says reminds me of an old legal saying, bad facts make bad law. And the facts here really are not the type of thing I think the Supreme Court wants to start tinkering with the law with these facts.
Yeah, you put that so well. And as Michael always said, not bad meaning bad, but bad meaning good, in which case it's not the road you want to go down.
That's right.
Run DMC, baby. But
I was going to say, run.
But to that point, and I don't mean this to be, overly unkind to Donald Trump, but what David is referring to is this is not a typical problem between presidents of different parties who disagree on many things. There isn't, and David, you could speak to this, there's not a lot of history or case law where the Supreme Court has to actually deal with a former president who says, I still want to hit the nuclear button. Well, dude, you're not president anymore. I still want to declare foreign policy. Well, you're not president anymore. I want executive privilege. Well, again, you could come up with other minute examples that have more, more to deal with the archives that are a little more particular presidential papers. But the idea that the active power, David, would be overruling the current president's position for the former president, they don't even usually get asked to do that.
Yeah, the executive privilege rests with the executive, not the former executive. And that's his big challenge here. I'm not a constitutional scholar, but I don't think that's so difficult to comprehend that the Supreme Court is going to feel like they need to take that issue up, particularly under these facts.
Well, David, I'm saying this not because I learned law from you, but I think viewers might agree. You keep it very clear and concise, so it's a real good breakdown on those two legal issues. Michael, we have to deal with something later in the hour, and it's going to be less serious than this segment, and that's all I'm going to say for now. I'll see you later.
All right.
Thanks to both of you.